Everyone, on behalf of the Bar Association of India, it is my great pleasure to welcome you to the 35th POLA Summit here at the India Habitat Center, New Delhi. We are lucky to be hosting presidents and representatives of leading bar association. Kim, yeah, please. Thank you. Can I now request Mr. Rawat to please hand over bouquet to our guest of honor, Mr. R. Venkataraman, our Attorney General. I'm sorry, we're trying to press ahead because our chief guest has to attend a presidential reference hearing today at 10:30, so we have to sum it up quickly. May I now invite our President of Law Asia and Vice President of Bar Association of India, Mr. Shyam Diwan, to deliver his opening remarks and introduction.
Thank you, Amarjit. The Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, the Honorable Mr. Justice Varale, Judge, Supreme Court of India, Mr. R. Venkatramani, Attorney General for India and Honorary Chairman ex officio of the Bar Association of India, Mr. Prashant Kumar, President, Bar Association of India, Amarjit Singh Bedi, Honorary Secretary, Bar Association of India, the most important person in this room for many of you who've obtained a visa to arrive here, Rachana Srivastav, Vice President of the Bar Association of India, distinguished bar leaders, ladies and gentlemen. It is my distinct pleasure to welcome you to New Delhi, an ancient settlement on the banks of the river Yamuna, and which currently serves as the capital of the most populous country in the world. A special greeting, namaste, to all our first-time visitors to India. I'm so glad that the POLA Summit has not, as yet, succumbed to the seduction of Zoom. It's indeed a pleasure for the Bar Association of India to host you in person. How wonderful that our deliberations over the next 2 days will take place face-to-face across this room, and without that infernal instruction, please put your questions in the chat box. As you will experience, Delhi has much to offer beyond its notorious air quality index reading. Incidentally, the showers of the past few days has ensured that we are in good air territory for now. Please do take the time to visit the grand medieval monuments, the bustling bazaars, and the diverse food scenes. You have here a range of religious landmarks: Hindu, Muslim, Sikh, Buddhist, Christian, Jain, Zoroastrian, Baha'i, where even the non-believers amongst us may experience a spiritual stirring. Then we have a set of modern landmarks in the secular tradition. Amongst them, our Supreme Court building, whose facade Indians associate with liberty, dignity, and justice, that triumvirate of values which drew many of you into the world of law. This summit is exceptionally diverse, and when I did a count late last evening, we had over 50 distinguished delegates representing 22 jurisdictions. Thank you for traveling great distances to participate in these deliberations. In many ways, Delhi mirrors India, rooted in history, enriched by diversity, and energized by the aspirations of a young and future-looking population. To speak of Delhi is to speak of India's vibrancy, resilience, and promise. At summits like these, global events invariably cast a shadow. An ancient Indian political text, the Arthashastra, foreshadowed a philosophy in wide currency today. It goes by the name Matsya Nyaya, or law of the fish. Matsya is fish, Nyaya is law. And the Arthashastra tells us that the bigger fish eat the smaller fish. The Arthashastra cautions us that in the absence of a fair magistrate, the strong will swallow the weak. However, under the protection of an impartial magistrate, order will return and the weak will resist the strong. I trust that our deliberations will reject Matsya Nyaya for a more just order. Perhaps we should be guided by the Nobel laureate Amartya Sen's idea of justice when he argues that the real Nyaya or justice is about reducing injustice across communities in observable ways. And for that, surely, we require an independent bar, an independent judiciary, the deepening of democracy, and a fearless appetite for courage. I thank you all and welcome you to this summit.
Thank you so much, Mr. Diwan. Now may I request our President, Mr. Prashant Kumar, President of the Bar Association of India, to deliver his presidential address.
Good morning, Honorable Justice Vikram Nath, Judge, Supreme Court of India, Honorable Justice Varale, Judge, Supreme Court of India, Mr. R. Venkatramani, Attorney General and Honorary Chairman of the Bar Association of India, my colleagues, Shyam Diwan, President Law Asia, Rachna Srivastav, Vice President, Mr. Amarjit Singh Bedi, Secretary General, Mr. Chandyok, President-elect, and all the tall leaders of the bar from Asia Pacific and beyond. So I welcome you. I remember this venue very distinctly when 2001 POLA took place, the 11th POLA, in this very room. And I was a volunteer then, sitting on the side row on a chair. So it's a pleasure for me today, especially to host all of you in New Delhi. That meeting taught a very vital learning about the Asian culture. We had a simultaneous meeting of Law Asia Council, and there were the two candidates for presidentship of Law Asia. One was late Mr. G.L. Sanghi, sponsored by India, and the other Mr. Gordon Hughes, who was from Australia, and he currently is very much there in Law Asia. So there was a tie of votes. So when the tie was there, the first person to react was Mr. G.L. Sanghi. He said, I cast my vote for God. So that's the tradition we perceive our Asian family of law associations and lawyers. Mr. Sanghi became president after one term, but this was the spirit, and I think we have been able to sustain that spirit throughout. And that is what keeps us together, not just the shared values of legal profession, but the capacity and the inclination to know each other better, the appetite to work with each other. And this summit is very important because here we all sit and deliberate issues which we may not discuss in open, issues which concern independence of profession, which concerns independence of judiciary, which concern the general state of rule of law in each jurisdiction. So that way this organization is very unique, where we can discuss, we can share our experiences, and we can see whether there is a possible way out, how we can help each other. And in practice, that has happened quite a number of occasions. where we have supported each other, we have stood by each other, and once, even in regimes where the appetite for these issues is less or minimal, or certain oppressive elements have come in the course of political changes, the very fact that there is an international glare on the developments has helped the situation to ease out and resolve ultimately. So that is the purpose and that is the real objective of this organization. Apart from that, we have discussion in a larger group on various topics, and this year's theme is before you. All topics are quite forward-looking, and this is my, I was a convener in 2015 POLA in Goa. I was given the honor of co-chairing in 2016 in Sri Lanka and 2017 in Mongolia by our Mongolian friends, and this is my third and final POLA in my tenure to chair it, and it's a special honor and it's a nostalgic moment as well for me. But it will remain my family. I'll be around there. So once again, I welcome you all. Thank you.
Thank you, Mr. President. Now may I request our guest of honor, the Attorney General for India and Honorary Chairman of the Bar Association of India, Shri R. Venkataramani. May I request him to kindly address the gathering.
Let me welcome those of you who travel long distances. And to travel these days is comfortable, easy as we think, but unlike Columbus and Captain Cook traveled all those days. But you need to have a mind to travel. You need to have a commitment to travel and to be part of a global community of those who want to see a new world and change a new world order. So I invite each and every one of you for this global commitment, particularly from the Asian continent. And as probably things will unfold, we are going to play a huge role in a new understanding of rule of law at a global level and rule of law within domestic frontiers. So with that few introductory words, since the learned judge has to go to the court as early as possible, I want to share a few concerns. What volunteers can do. Prashant talked about volunteers can move from the back side to the front side and make changes happen in a big way. He's a great example. And he mentioned about just Mr. C.L. Sanghi. We're talking about ties. The tie which Sanghi voted, I think, brought about greater ties. So it all depends on what ties we make among each other by losing something which is not very precious. So there are, long ago in 1958, when Justice Brennan was addressing association, bar association, he said senior lawyers do seem to be listening, but in their innermost mind they're thinking something else. And he said, I would like to address the law students. Probably they'd like to be more receptive. But fortunately there are no law students here. All of you will be as receptive because each of you have come to share your own thoughts. And we have a common travel, common journey, and a common end and pursuits. Now, the supreme value of democracy, all of us understand, is the worth and dignity of each individual. And why do you have a constitution? And why do you talk about rule of law? And if liberty is as important for each and every one of us who live at a very preferred state of life, it is equally important for those who are aspiring to live with dignity and worth. So how do we make it all possible? The Cold War era, happily, is dead. But we have new other wars which are on the horizon. How do we therefore ensure the legal community that we coin new understandings of world equation on equal regard and equal status for all nations? And how do you also ensure these coining of new understandings percolate within the domestic frontiers? And each democracy, within its own special features and history, is able to perform and move towards common goals of peace and world order. I think all of us are committed to that. I'm sure in today's session and tomorrow and day after, we'll be talking about it more and more. But I only want to say this finally. Each one of us, I think, individually are committed to something good and beyond ourselves. And beyond ourselves, we think about that means, and I remember John Adams long ago, President of the United States in 1789, talking about And I study war and peace because my sons must study mathematics and philosophy. And they study mathematics, philosophy because my grandsons will study architecture, peace, tapestry, beauty, etc., etc. Therefore, you're talking about the great grandsons who will be studying not war and peace, will be studying mathematics, philosophy, values of life, dignity, and so on and so forth. I think we're committed to each one of those values. Let us be committed, continue to be committed, and have a common journey where the globe will no longer be torn with wars and all those lack of humanity is considered. Thank you so much for your attention.
Thank you so much. Now may I invite our Chief Guest, Honorable Justice Vikram Nath, Judge of Supreme Court of India, to deliver his address.
A very warm good morning to everyone. My esteemed colleague, Brother Prasanna Varale, Learned Attorney General of India, Mr. Venkat Ramani, President of the Bar Association of India, Mr. Prashant Kumar, Senior Advocate and President of Law Asia, Mr. Shyam Diwan, Vice President of the Bar Association of India, Ms. Rachna Srivastava, Mr. Bedi, General Secretary, distinguished presidents and office bearers of Lawyers Association from across the Asia Pacific region, esteemed members of the legal profession, ladies and gentlemen. It is my privilege to extend a very warm welcome to all of you at the 35th POLA Summit here in New Delhi. This summit is a proud milestone in a journey that began more than 3 decades ago, when presidents of law associations across Asia first came together under the banner of POLA. What began as a forum for dialogue has grown into a movement of ideas, friendships, and collaboration, anchored in a shared commitment to the law, to democracy, and to justice. Today, as this historic city hosts the 35th POLA Summit, the tradition of regional dialogue continues with renewed purpose. The decision to call this gathering a summit reflects both the stature of this forum and its role as a common meeting point for leaders of the bar to exchange ideas, reflect on shared challenges, and chart a collective way forward. Over the years, POLA has been more than an annual event. It has become an institutional guardian of the rule of law. By bringing together the leaderships of bar association across Asia Pacific, it has defended the independence of the legal profession and upheld professional ethics, and reminded us about the importance of free and independent lawyers. The theme chosen for this 35th POLA Summit being Developments in Law, Concerns and Challenges for the Legal Profession in Asia Pacific could not be more timely. We meet in an age of transformation. Technology is altering how justice is delivered. Social media is reshaping how it is perceived, and the contours of rights and freedoms are being tested daily. Against this backdrop, our deliberations in the coming days will address some of the most pressing questions facing the legal community. The working sessions will engage with the emerging challenges and opportunities in law. The session on courtrooms without walls will remind us that courts today are not confined to physical spaces. With live streaming, virtual hearings, and the growing presence of artificial intelligence, we must ask, how can we safeguard judicial impartiality while embracing transparency and innovation? The session on human rights enforcement will explore the balance between binding treaties and voluntary norms in human rights, and whether soft law can deliver real protection or remain only aspirational. The session on AI in legal practice, education, and litigation is an acknowledgement that the age of the AI lawyer is fast approaching. Yet, no algorithm can replace the human conscience, the ethical compass, and the moral responsibility that lie at the heart of our profession. And finally, the session on inclusivity and intersectionality will remind us that the future of law must be representative, diverse, and equitable if it is to command legitimacy in the eyes of all citizens. Colleagues, The challenges we face are not confined to national borders. Technology does not stop at checkpoints, and neither do questions of rights, environment, migration, or justice. That is why POLA is so vital, as it enables us to see beyond narrow horizons and to shape regional responses to global questions. We must continue to uphold the independence of our bar associations. We must continue to improve legal education, for it is the foundation upon which the next generation of lawyers will build. And we must continue to stand together across jurisdictions, across cultures, across traditions, so that the voice of justice remains strong and united in Asia Pacific. As this summit begins, it is worth remembering that the law is not defined only by statutes and precedents, but equally by the values of fairness, equality, dignity, and courage. It is these values that should guide the deliberations over the next 2 days. I have no doubt that the discussions here will be rich, thoughtful, and forward-looking. They will prepare us not only to confront the challenges of tomorrow, but also to shape them into opportunities. I once again extend my warmest welcome to all distinguished delegates and thank the Bar Association of India for hosting this landmark event. May the 35th POLA Summit strengthen our resolve, deepen our friendships, and reaffirm our commitment to the rule of law and democracy across our region. And in the end, I expect and I am sure that all of you will carry not only some additions to your legal knowledge but also some very good memories and enjoy the good food, the spicy Indian delicacies. I am sure all of you will take good memories back home. Thank you very much.
Thank you, my lords, for your guidance and word of wisdom. Now may I request Ms. Rachna Srivastav, our Vice President, to give vote of thanks. And thanks again to her to interact with Ministry of External Affairs to get the visas at the last moment.
Thank you, Amarjit. Namaste, good morning to all. Chief Guest, Honorable Justice Vikramnath, Judge Supreme Court of India, Justice Varale, Judge Supreme Court of India, Mr. R. Venkatramani, the Attorney General for India and our Vice Chairman, Mr. Prashant Kumar, President, Mr. Amarjit Singh Chandio, President-elect, Mr. Shyam Devan, President Law Asia, and our Vice President, Amarjit Bedi, General Secretary, distinguished guests in the audience, ladies and gentlemen. We are delighted that POLA is back in India again after a decade. We had hosted POLA Summit in 2015 in Goa, and since then, POLA family has expanded larger, and now we have 23 jurisdictions participating this year with the 4th International Associations as observers to share the development of law in their respective jurisdictions. After 2 days, we are also starting a Rule of Law Convention, International Rule of Law Convention, where we'll be signing 11 MOUs with different jurisdictions and 17 bilateral meetings. Due to this time constraint, I'm being very brief. I have just got a mandamus. So adding briefly that I'm truly honored to propose this vote of thanks on behalf of the Bar Association of India on the occasion of opening summit of POLA. First and foremost, I will thank Justice, our Chief Guest, Honorable Justice Vikramnath, for accepting our invitation after great persuasion and gracing this occasion. Sir, your insight and kind words have truly inspired us today. A huge thank you for sharing your knowledge and perspective on the theme of POLA, developments in law, concerns and challenges for the legal profession in East Asia Pacific in such an engaging and relatable way. Your work sparked new thoughts and gave us a fresh perspective on the subject. Our heartfelt thanks to our guest of honor, Shri R. Venkatramani, Attorney General for India, for taking your precious time out for today's inaugural session. Sir, your journey and message on the subject has motivated all of us today. In closing, I wish to express my deepest gratitude to each one of you for your gracious presence and starting the summit with immense enthusiasm and excitement to make this summit a memorable success. It is rightly said, great moments are born from great appreciation. Thank you so much to each one of you. Thank you so much.
Thank you. May we now request you to join us for tea and coffee in the foyer, and working session will start. Yeah.
Thank you, thank you.
Thank you, Mr.
Thank you very much. Thank you.
Thank you, Your Lordship, for joining us. Now may I request our delegates to please join us in the foyer for tea and coffee, and our working session will start at 10:30.
The speakers of the first working session to be on the dais. Yes.
जो भी प्रेसिडेंट का वो करना है ना, इसलिए 1:45 करना है इंस्टेड ऑफ 2 o'clock.
क्या चीज़?
अभी 1:45 पे शुरू होना है ना, 2 बजे की जगह 1:45 पे प्रेसिडेंट
मीटिंग. अच्छा.
1:45. तो अर्ली लंच होगा. अर्ली लंच 12:30. President Summit meeting.
Please, I have to make an important announcement that the President Summit Meeting 1 will commence at 1:45 instead of 2 p.m. Thank you. Over to the moderator.
A very good morning to all of you once again, and welcome to the first business session. If you're looking at the printed brochure, then you will notice that I am sort of a bit of an imposter, because you have Mr. S.S. Naganand, who was to moderate this session. Mr. Naganand unfortunately couldn't make it. He was all set to be here. Mr. Naganand is the Vice President of the Bar Association of India. He's also an Executive Committee member of Law Asia. He's based out of Bengaluru, where we had the annual conference of Law Asia in 2023. And it just so happened that he was to come in last evening. Last evening, as some of you, yesterday, as some of you might know, was Ganesh Chaturthi, which was a very important celebration of, where we sort of worship, and we have a few rituals for the elephant-headed god Ganesh. And Mr. Naganand, I know, has his own, they have a family temple outside of Bengaluru, and the morning he was going to spend there, and then late evening he was to come. But unfortunately, he hasn't made it, he wasn't able to make it because of some personal reasons. So I inquired from him, do you have any notes in terms of what you wished to share and your deliberations with your co-panelists? And he said, Shyam, they're all so accomplished that we didn't really think of that as a necessity moving forward. But we have a very, very distinguished panel here. We have Ms. Juliana Warner, who's the President of the Law Council of Australia. We have Mr. Rodden Tong, who's the President of the Law Society of Hong Kong. Lisa Sam, President of the Law Society of Singapore. Mr. Chen Xiong, member of the Foreign Related Legal Services Committee of the All China Lawyers Association. And Mr. Jung Woo Kim, who is a member of the International Committee of the Korean Bar Association. So without further ado, each one is very, very distinguished in his field. Apart from being a leader of the bar, is an ace practitioner. And we will be sharing over the next couple of hours courtrooms without walls, AI, social media, and the rule of law. I'll chip in with some perspectives from my home jurisdiction, which is India, as we move along. But I invite first President Juliana Warner either to make a presentation from the seat, if she likes, from an oral, or if you prefers to stand at the podium. Please welcome Juliana.
No. Good morning, everyone, and I'm very excited to be here. This is my very first POLA. It's a wonderful experience. We really enjoy Charlotte, who's my colleague from Australia, who's much more experienced in POLAs than I am, and I have been very much enjoying ourselves. In any event, our topic for today is AI and social media and the rule of law. AI-assisted technology is now being used in many aspects of legal work, of course. It is here to stay. I remember in about 1994, a friend of mine who was a bit tech-savvy had spent all night on her computer, and she was speaking to me and she said, "It's the internet. It's this thing called the internet. It is going to change your life." And of course it did. And that is exactly what AI is going to do. So we have to understand it, embrace it, make use of it, understand the limitations, and work through, because that's what all of our children are going to be doing. This is going to be technology that they will be learning at the same time as they learn to write and speak and count and so forth. So there's a lot of work that's been going on in Australia about what this means for the legal profession, and Law Council of Australia and the courts have been trying to do a lot of work to grapple with what the issues are and how to make sure that it's an adjunct through the rule of law and of assistance and doesn't undermine it. Because I think AI and social media, while they can improve people's interactions with the court, they can be quite problematic in a lot of areas and impact on fair trial principles. So it's really important that we continue to understand all of these issues. AI has been, in its earliest forms, in use in the legal profession in Australia for at least 15 years in document review and document production and all of that kind of thing. And the Supreme Court, the Chief Justice of the Supreme Court in New South Wales recently issued a practice note for all practitioners, which was actually quite prescriptive, and it more or less said, no, we're not using AI. And that immediately caused a vast amount of consternation throughout the profession, because of course all of us have been using AI for e-discovery for quite some time, and nobody wants to go back to reading 5 million documents, as if you could anyway. But in any event, that was changed. But over the last 18 months, I think that generative AI, which I will refer to as Gen AI, is creeping into everything. And it's being used for creating production of chronologies, summarising cases, conducting legal research, analysing witness statements, and all the rest of it. But the problem, of course, is it wants to please. So there's an awful lot of hallucination that happens with AI at the moment, and of course that is something we are going to have to work through. So the judges in our federal courts have been raising they've been raising the importance of legal practitioners, making sure that they understand that whatever it is that they're putting in front of the court is consistent with the overriding duty to the court and to the administration of justice. And you just can't say, I got it from AI, without understanding exactly what that means. So there's the regulation of AI is now a pretty big topic in Australia, and the federal court's recently been consulting about, well, what sort of guidelines should the court have? Because it's really important that we don't crush innovation and that we don't stop things improving, but at the same time we can't allow the court's fundamental structure and function to be undermined by it. So what we have suggested to them is that we have separate guidelines for legal practitioners, expert witnesses, self-represented litigants, the public, and the judiciary as well, because there are different considerations that apply for each of those areas of persons who participate in the justice system. We have differing views in the Law Council because, of course, we're lawyers, so of course we have differing views about how to do things, but we think probably a hybrid framework is probably best for regulation of this. So guardrails, if you like, or guidelines for certain things, but some things I think should be specifically prohibited. My personal view is that we should not be using Gen AI for affidavits or evidence that's going to the court. And I think the reason I became convinced of that was because I was on a committee, and one of the committee members took a fact situation, put it through 2 different AI tools, came up with something that caught all the main facts, sort of sounded okay. They were quite different, and I could just see that if you put something like that in front of a witness, they'd say, yeah, that's right, that'll be right, that'll do, and with absolutely no intellectual input coming from the witness to make sure that what's going to the court is the witness's own recollection. It's sort of like witness coaching on steroids, so I don't think we should be using AI in that sphere. I think that kind of hybrid approach will probably allow sufficient flexibility to enable the technology to be used appropriately. But of course it has to be underpinned by our understanding that we have overriding professional and ethical responsibilities. So it's a bit like one of when I was a very junior lawyer, I remember one of the partners saying to me in the drafting of a document, I am responsible for the placement of the very last comma in the document. And I think that's absolutely right. And it's exactly the same if you're putting evidence before a court. You have to be responsible, or submissions, you have to be responsible for every single word to make sure that it's right. So I think there's a particular challenge with AI and self-represented litigants, because with the best will in the world, they're going to use AI, it's going to have a lot of rubbish in it, it's going to waste a lot of time in court. They're not going to understand that, in fact, there's rubbish in there, and they don't have the same ethical obligations that we do, so I think particular constraints might be necessary around that. I think there needs to be very careful consideration used in relation to AI and automatic decision making by governments. We had a big scandal a few years ago, which was ultimately called the robo-debt scandal, and in the Department of Social Security what they decided to do was have an automated system that would make decisions about whether or not Social Security recipients had cheated on their on their, claims. And they used a particular way of doing it, which turned out to be completely flawed. And it caused huge harm to very vulnerable people, and in fact a number of people suicided because they were receiving these barrage of, you now owe $50,000, you know, owe $75,000, and it was quite dreadful. And there was a royal commission into it, and a number of the public servants who had been involved in it ultimately got referred to the corruption commission over it. So I think there's a lot of serious consideration there. I think AI and judicial decision making is quite interesting. I think the family court in Australia is using it quite innovatively. They've got a tool which is used for family law called it's called the split up tool, which can predict how a couple's assets should be divided up, and that's been found to be quite helpful in resolving disputes between warring spouses. There's been a lot of commentary on how AI could replace judges in low-value claims, but I think you have the same kind of concerns about that in as you do in government automated decision-making situations. My personal view is I'd prefer a judge any day, but maybe that's not a universal view. But it is certainly important that we keep innovating, we keep trialling how we do this, we keep understanding and learning from where things are, where mistakes are made, and we keep trying to refine it. This is a tool that will make our lives easier if we use it properly and thoughtfully and considerably. Now, I wanted to talk a little about the courts and social media, because there's been quite a lot going on in Australia about this, with the introduction of live streaming, which of course started during the pandemic when we were doing live streaming of judgments. Court hearings became all remote. There was, obviously no face-to-face. And things did work quite well. We worked out how to do it. When the pandemic was over, many of our courts decided to revert back to in-person. And I think that's a preference for particular judges, but it does give people the opportunity to think, well, is this a witness that you can deal with remotely, or is this a witness that you really should see sitting right in front of you? But there were a number of these live-streamed decisions. The federal court in Australia live streams most of them, but it's down to the individual judge, and we have some judges who are possibly a little bit more on the theatrical side, shall I say, who quite like the idea of live streaming judges, particularly if it's an exciting case that has gripped the media's attention. We had quite a big defamation case recently where there'd been an allegation of assault in Parliament House, and there had been a lot of media about it, and the young man concerned had been charged, but the criminal trial had been abandoned because of juror misconduct to do with social media. They'd been looking at their social media. So the trial went off, and then, as the judge said in the live streamed case, he went back for his hat, having escaped the lion's den, and he sued the plaintiff for defamation. The defamation judgment was live streamed. It went for 2.5 hours, and practically everybody in my office was watching it, gripped right to the end about who was going to win or lose. I don't know that that is really the outcome that we want from live streaming of cases. There is a lot of consideration now being given to what is the downside of live streaming cases. One of our very senior King's Counsel, Matt Collins, who has appeared in 4 of these very large, very prominent and high-profile cases, since the COVID pandemic, has said that it was actually quite difficult personally, because if everything's live streamed and there's much on social media, the people who are involved in the trial actually get trolled. So people will find out where the barristers live and start stalking them. People will put stuff on, social media about how awful the barrister is, or the solicitor is, or the witness is, and that can be very, very chilling for the people involved, and particularly for victim survivors of sexual assault. A live streaming situation could take something that is already re-traumatising and make it infinitely worse. So I think there's a lot to be said for being very judicious about what is live streamed and what is not. And of course, if it's a jury trial, social media, of course, there's a lot on social media which is actually a sewer, and it can really cause problems, such as the trial in the criminal proceedings that I was talking about going off. So that is clearly a bit of a balancing act for our judges to think about, and I think these will be common issues throughout the world as this kind of technology becomes more and more pervasive and more usual, and we start seeing more and more innovation in the kind of technology that will be available to people in cases. So the other thing is that there have been some judges that have started doing their own social media, and I think that's probably not a great thing, frankly, because anything on social media that you say, of course, is there for good, and it's a bit like, the test that we have: don't write something in a letter to the other side if you wouldn't want to see it on the front page of the national newspaper. And I think there's a little bit of that in judges using social media. So I think, sort of in conclusion, we're going to keep our work going on all of these various issues. There's a lot to think about, and a lot that we can learn from each other about how we're all dealing with these particular issues confronting ourselves. And of course, the other big issue, which I think will probably be dealt with in a later session, is if our young lawyers are using social media all the time, and they are using Gen AI to learn, how are they going to learn? How is a first and second year lawyer going to become a useful third and fourth year lawyer if they're not getting their base level skills in the first place? So that's all I wanted to say for the moment.
Thank you very much. Meant to work. Okay. Thank you very much, Juliana. That was most interesting. I have a few questions which I'm going to reserve for later, including social media and the embargo or the guidelines for children in Australia, where Australia is a first. But may I turn this over to Roden, and who's going to make a PowerPoint presentation. Thank you very much, Roden.
Oh, yep, okay. Okay, good morning, everyone. President Diwan, fellow presidents, distinguished guests, ladies and gentlemen. It is truly my great honor to join the 35th of the POLA Summit here in New Delhi. It is in fact my first time here in India. And engage with all these esteemed colleagues from India, Australia, Singapore, China, and Korea in exploring AI, social media, and the rule of law from a legal perspective. Technology has redefined the world we live in, opening new frontiers of possibility. The use of AI in courtroom proceedings has become a practical reality across many jurisdictions worldwide. AI is increasingly being adapted in the legal sector, offering immense potential to enhance access to justice and transparency. Alongside with the impact on social media, the landscape of courtroom transparency has been significantly reshaped by broadening public access to information on the judiciary and legal proceedings, often almost instantly. However, it is imperative to acknowledge and address the complex concerns that AI and social media raise across multiple aspects, particularly in relation to integrity, ethics, individual rights, and the independence and impartiality of the judiciary. Use of such technology must be carefully managed to ensure that the rule of law remains the guiding framework in the digital era. Under the framework of one country, two systems, Hong Kong remains a common law jurisdiction and the only common law jurisdiction within China. Hong Kong is also the world's only bilingual common law jurisdiction in both Chinese and English. In Hong Kong, the judiciary has issued the guidelines on the use of generative artificial intelligence for judges, judicial officers, and support staff, emphasizing that judicial officers should ensure that all judicial decisions continue to be independently and personally made by themselves, and should not, under any circumstance, allow generative AI to take over performance of their judicial function. It's very similar to what President Warner just mentioned. This is a key affirmation of the importance of human discretion in judicial decision-making. The life of law has not been logic. It has been experience. In fact, there are cases around the world where judges and lawyers relied on AI or generative AI tools without adequate human oversight, leading to some unfortunate to serious professional consequence. A notable customary tale is the case of Roberto Mater versus Enrique Incorporation in the United States. In this instance, an inexperienced and under-resourced law firm mistakenly relied on ChatGPT to support litigation beyond its actual capabilities, in which the plaintiff's lawyers presented the court with precedent cases turned out to be conversations created by ChatGPT. Just 2 months ago, in a ruling delivered in June, a senior UK judge warned lawyers they could face criminal charges if they rely on fictitious AI-generated cases when presenting written judgments in court. 2 cases were cited as example. In the Allende case, counsel submitted 5 fictitious cases as evidence. She denied using generative AI and claimed the cases were found through general internet searches, though no sources could be identified. In the AI Horn case, the solicitor submitted a witness statement citing numerous authorities, 18 of which were found to be non-existent. Others were either misquoted or not relevant. The solicitor had relied on research provided by the client without independent verification. While the risks of AI are real, outright rejection is no longer a viable option. Its adoption in the legal profession is no longer a question of yes or no, but when, prompting us to carefully consider the opportunities and the challenge it may bring to the profession and the justice system. The Law Society of Hong Kong, which I represent, serves as both the self-regulatory body and professional association for solicitors in Hong Kong with over 13,000 members. It began its journey toward integrating AI into the legal profession 6 years ago. In 2009, we introduced Principles of Professional Conduct in the Hong Kong Solicitor Guide to Professional Conduct, to regulate the conduct of solicitors in the use of technology to ensure the compliance with legal and ethical requirements. A question that often crosses my mind is, when the day comes, and I believe it is not far off, that the use of AI becomes a norm in our legal practice. If a lawyer decides not to adopt technological advancement or AI in serving his clients, or incapable of doing so, will it be considered a breach of his professional duty to the client? Well, Principle 601 of our conduct guide may shed some light on the competency of using AI by lawyers, which suggests that a solicitor owes his client a duty to be competent to perform any legal services undertaken on the client's behalf, and must serve his client in a conscientious, diligent, prompt, and efficient manner. Separately, just last year, the Law Society has published a position paper, The Impact on Artificial Intelligence on the Legal Profession, which aimed to impress upon our profession and other stakeholders, including, among others, the government, the judiciary, and the legal professionals and academics, the urgent need of timely and proactive actions and reforms, so that we can guide the direction of the application of AI for the benefit of our profession as a whole. So for the audience who are interested in, please feel free to take a closer look by scanning the QR code here, so you can also can download our AI position paper. Well, I believe this approach resonates across our region. While AI enhances efficiency, it must never compromise our ethical foundations. As AI integrates into legal processes, judicial institutions must establish transparent protocols aligned with natural justice. With this in mind, we will continue exploring AI adoption in collaboration with a diverse ecosystem of stakeholders to support the advancement of the legal profession and ensure we remain future ready. While we have discussed data quality, another critical pillar for AI development is the accessibility and free flow of data. This indeed is one of Hong Kong's edges. On one hand, Hong Kong maintains a fully open policy with access to both domestic and global AI and tech platforms like DeepSeek, Google, Microsoft, Facebook, and LexisNexis. The open access ensures the legal professionals can tap into comprehensive database and cutting-edge tools to support accurate legal research and cross-jurisdictional practice. On the other hand, serving as both a super connector and super value adder, bridging the mainland and the rest of the world, Hong Kong is a crucial gateway to the Greater Bay Area in Guangdong, China. It is especially significant given the current limitation on data exports in the mainland. In 2023, the Hong Kong Innovation, Technology and Industry Bureau and Cyberspace Administration of China signed an MOU to jointly promote cross-boundary data free flow in the Greater Bay Area. Let me briefly highlight some key facts about the Greater Bay Area. The region comprises 2 special administrative regions, Hong Kong and Macau, and 9 mainland cities in Guangdong, covering an area of around 56,000 kilometers with a population of over 87 million. In 2024, the region's GDP exceeds US dollar 2.07 trillion, very close to Germany. What makes the Greater Bay Area truly exceptional is the legal framework one country, two systems, 3 jurisdictions, which encompasses the civil law system in the mainland China, the common law system in Hong Kong, and a legal system in Macau, broadly based in Portuguese law. The remarkable growth of the Greater Bay Area has unlocked wide opportunity for professionals, particularly legal practitioners. Among our 13,000 members, around 400 Hong Kong lawyers are currently dual qualified to practice both Hong Kong common law and mainland civil law in the Greater Bay Area. These GBA lawyers are well positioned to offer cross-jurisdictional legal services supporting enterprise in expanding their business through transformation and collaboration with outside business and technology partners. leveraging their global perspectives, a deep understanding of mainland culture, a full access of various global data resources and technologies. They serve as a vital bridge between legal systems and innovation. Another disruptive trend that we, as legal professional institutions, must pay close attention to is social media. Social media has transformed how information is shared and consumed. But they also raise major concern around accuracy and integrity of information, privacy risks, and public inference and perception. The widespread dissemination of information does not always lead to truth or justice. In 2022, the Hong Kong judiciary published the Guide to Judicial Conduct, an update to the 2004 edition. The updates took into account of the impact of the advancement in information technology, particularly the use of social media in daily life. Under the Basic Law of Hong Kong Special Administrative Region, the Hong Kong judiciary is an independent judiciary that upholds the rule of law and administers justice without fear or favor, bias, or prejudice. The guide reminds judges to always uphold independence, impartiality, integrity, and propriety, especially on social media where content is instantly visible, publicly accessible, and often permanent. Judges must remain mindful of public perception and act in ways that perceive confidence in the justice system. That said, what's more concerning is that very often, content posted on social media may not necessarily reflect a thorough examination of the whole truth. The impact of the public must not be underestimated. Fermented, biased, or even untrue narratives on social media often lead to confusion. In certain high-profile cases, debates, or social media platforms may give rise to some sort of media trials, which risk undermining judicial impartiality and eroding public trust in the justice system. Upholding the rule of law is of paramount importance, with judicial independence serving as a vital safeguard that ensures courts can exercise judicial power independently. Let me give you an example. Many of you may have come across media coverage and social media commentary surrounding recent legal proceedings in Hong Kong, which have attracted international attention and sparked debate over cases that remain ongoing. While we respect the right to access to information, as it serves as an integral part of freedom of expression and is an important tool for promoting the rule of law, other rights, and building trust. In Hong Kong, Article 27, Chapter 3 of the Basic Law enshrines the fundamental right to freedom of opinion and expression. It guarantees that all residents shall have freedom of speech, of the press and of publication, freedom of association, of assembly, of possession, and of demonstration, and the right and freedom to form and join trade unions and to strike. It aligns with Article 19 of the United Nations Universal Declaration of Human Rights, reflecting Hong Kong's commitment to upholding international human rights standards. Yet, in the digital age, there's a big question mark here. How to ensure that online information is accurate, impartial, and complete, with examination of the cases as thorough as the courts do? Article 19 of the International Covenant on Civil and Political Rights recognize that freedom of expression is not without limits. These rights come with special duties and responsibilities and may be subject to restrictions, but only when prescribed by law and necessary to protect the rights or reputations of others or to safeguard national security, public order, public health, or morals. In the digital age, the right to access information is not only about speed or format. More importantly, it is about ensuring fairness, impartiality, and justice to all, principles that lie at the heart of trustworthy and equitable information ecosystem. The legal framework reflects a core principle of constitutional jurisprudence that fundamental freedoms must be exercised in balance with the rights of others and the collective interests of society. Freedom of expression, while indispensable, must be exercised with responsibility and in accordance with the rule of law. In addition, what would be the implication when general public receive online information before the judge's final ruling? In Hong Kong, judicial independence is constitutionally enshrined in the Basic Law. For instance, Article 2 guarantees independent judicial power, including that of final adjudication, in accordance with the provisions of the Basic Law. Article 19 provides that Hong Kong shall be vested in independent judicial power, and Article 85 provides that the courts shall exercise judicial power independently, free from anti-interference. The law holds judges and us, legal professionals, to a much higher standards when engaging with such content. Yet, the broader societal influence of misinformation remains significant, frequently leading to public confusion and distorted understanding. This is a quick question for all of us to explore and discuss. Under this disruption of rapid technological change, legal professional bodies must lead with clarity, integrity, and foresight. AI and social media are irresponsible force, but how we can better leverage the technologies to ensure justice can be served properly. The future of law is human guide. Cases of fabricated precedents remind us technology is only as reliable as the professional who violate it. Our ethical judgment must always lead the way. By establishing the robust ethical frameworks and investing in continuous training, we empower our members to navigate innovation responsibly, safeguarding both our professional standards and the rule of law. Public education is equally crucial in this effort. In this digital era, our role as ethical guidance has never been more vital. Just as New Delhi bridged tradition and progress, let us build a legal future that honors our shared values and embrace technology with wisdom, professional ethics, and responsibility. Thank you very much.
Thank you very much, Jordan. May I request Lisa to make her presentation?
Good morning, everyone. I'm just going to cover about social media, the rule of law, and the role of lawyers in this session. I have some slides, but they are not on the screen yet. Yes. I think it's kind of cut off. Is it possible to make it, resize it? Okay. Okay, so I'll start off with the fact that mass media has always influenced popular perceptions of the judiciary and the legal system. However, the lack of oversight on social media has been a game changer when dealing with public confidence in law. So currently, I think it's known to everyone that social media is the new public square, and it shapes society's perception of justice, the judiciary, and the efficacy of the legal system. So my secretariat staff said that since I'm covering social media, they wanted to put in all the colors and all that to make it trendy. So challenge number one is as I said, is the lack of oversight of social media. It can dent public confidence in the rule of law. And the torrent of misinformation and confirmatory bias can polarize and propagate viewpoints. And it is difficult for the public to understand the decision of the court is based on facts, evidence, law, and not public sentiment swayed by social media. And there is a new term that has come up called emotivism, which is the view that moral judgments do not function as statement of fact, but rather as expressions of feelings. So how can we ensure that the rule of law stands firm in the face of this digital onslaught? So The concept of social media affecting the rule of law has always been fairly complex, and it is, in a way, a double-edged sword. I will just set out the pros and cons to share with everyone. So on the one hand, social media expands accessibility to information, it gives voice to the marginalized communities, and exposes abuse and corruption. But some of the dangers are clear as systemic, such as misinformation and disinformation. There are distorted facts eroding trust in institutions. There's a trial by social media. It undermines due process, so individuals are condemned online before they ever step into a courtroom. So one example is the Johnny Depp and the Amber Heard trial. And algorithm-driven polarization, so this popularity contest where social media influencers or prominent online figures with millions of followers wield the power to speak polarized viewpoints or propagate bias. It makes it very difficult for the public or juries to understand that the decision or result is based on facts of the case, the evidence, the law, and not the public sentiment swayed by social media. And attacks on judges weakens independence, so online harassment and attacks against judges, prosecutors, and lawyers tends to weaken judicial independence and discourage lawful but unpopular decisions. So media pluralism has also eroded. So what is the perception of human rights in the digital era? It is inseparable from the protection of fundamental rights, and automated content moderation often results in arbitrary censorship. Unchecked hate speech suppresses democratic participation, and algorithms driven by profit will dictate whose rights are silenced. So what is the role of lawyers and bar associations? The view is, for us, is that social media can either enhance or erode the rule of law. The outcome depends on how we, as guardians of justice, respond. So we must, as defenders of due process, remind society that justice must be done in courts and not in hashtags or online petitions. It is our duty to speak out against trial by social media and to uphold the presumption of innocence. We are also protectors of judicial independence. We must defend judges and fellow lawyers when they come under unfair attack online. And the independence of the judiciary is a cornerstone of the rule of law, and it cannot be left vulnerable to digital intimidation. And third, educators and moderators in public debate. We must use our voice individually and collectively to clarify the law, counter misinformation, and guide the public towards truth and reasoned discussion. The law must not be drowned out by noise. Fourthly, as ethical leaders, we must ensure our conduct online reflects the dignity of the profession. So law societies and bar associations should develop ethical guidelines to ensure a digital presence that upholds public trust. And fifth, as conveners of justice, we must consider multi-stakeholders in our response. So lawyers are uniquely placed to ensure regulation is balanced and the rights are protected and justice is not left behind. So in real terms, what can bar associations do? It is increasingly important that public and legal education campaigns using simple, accessible content to explain legal processes and rights are required. So there seems to be a need in the education of legal systems in school, including civics and in the importance of the rule of law, providing examples of how it affects citizens' rights. There also is a need to have a rapid response to disinformation. So bar associations may have to intervene quickly when false narratives about the law or courts spread online. Bar associations may consider developing ethical guidelines for lawyers online, equipping our lawyers with clear guidelines for responsible online engagements, supporting the judiciary and legal professions legal professionals under online attack, so issuance of the collective statements defending independence when it's threatened by digital attacks, and also to engage all parties to mediate and to emphasize the points stated above. And lastly, advocate balanced regulation, including requiring social media companies to undertake increased monitoring to prevent the display of content related to specific cases requiring intervention. So there is a need to protect free expressions, but combat hate speech and disinformation and the cancel culture. And lastly, to share best practices across jurisdiction, because the challenges of social media do not stop at national borders. In closing, I would say that the rule of law requires protection in the digital age. Threats now come from digital screens, so lawyers must step forward, and Bar Association should lead and turn social media from a danger into a tool for justice. We should emphasize our role as the guardians of truth, fairness, and justice, and of course affirm using wisdom, integrity, and courage to ensure that the law remain a compass for truth, stability, and fairness, no matter how loud the noise the online world has become. Thank you.
Thank you very much, Lisa, for that presentation. And may I invite Chen Xiong, member from the Foreign Related Legal Services Committee of the All China Lawyers Association, to make his presentation. I do know that it was quite a task getting here, and perhaps with some change in airline tickets because of the challenges posed by the visa requirements. So we're really delighted that you're with us in New Delhi. Thank you.
Thank you, Mr. Chair. Thank you very much for your facilitation for our visa process. Okay. Good morning, everyone. First, I like very great honor standing here to share some ideas of this session. My topic of this session is legal innovations in the use of AI in China. I'd like to share some Chinese legal professions exploration and reflections on AI innovations from two perspectives. First one, application scenario of AI. Second, and some challenges and also risk management of AI. So, as we know, artificial intelligence tools can quickly and accurately retrieve information such as regulations, laws, and case precedents, significantly improving search efficiency. For example, legal database, the Peking University legal information platform use intelligent algorithm to instant locate relevant legal provisions and also similar cases, and generally enhancing retrieval efficiency. And AI employs natural language processing technology to extract key information and also legal opinions from the texts. Assisting in-depth legal analysis, for instance, as AI tools like Kimi and also Doubao in China can read, use updated documents, not generate content outlines and based on prompts, saving considerable time when reading and organizing texts. Second, in judicial field, AI-assisted adjudication and online dispute resolutions have emerged in exemplary models. Since 2019, the Hangzhou Intellect Court has launched intelligence evidence analysis system using cutting-edge technologies such as blockchain, AI, big data, and cloud computing to automate repetitive tasks, significantly reducing that trial circles. And also Shenzhen Court of International Arbitration, cloud arbitration platform combines blockchain evidence storage with AI mediation algorithm, providing parties with more efficient and convenient arbitration services. And third, in judicial litigation, further highlighting AI roles in judicial activities is the Supreme People's Court of the Peoples of China recent emphasis on element-based adjudication. For example, as early as 2016, the Supreme People's Court issued the several opinions on further promoting the diversion of complex and simple cases to optimizing judicial resources allocation, providing clear guidance for element-based adjudication. And with the advancement of AI technology, on March 4th, 2024, the Supreme People's Court and the Ministry of Justice and the All China's Lawyers Association jointly issued a notice introducing standardized element and based templates for statements and claim, and also defense in 11 common types of civil cases. By December 31st, 2024, the Supreme People's Court required nationwide courts to fully adopt these templates by 2025. This standardization helps judges quickly identify key disputes, supporting the efficiency implementation of element-based adjudication. And third perspective is AI use in precise control in risk management. AI has fundamental capabilities such as NLP and logistic analysis. With specialized legal domain model basis, AI can automatically review contracts, identify potential risks, inconsistencies, and loopholes. In practice, some legal professions have begun using AI to assist in contract review. For example, electric contract platform like Food Data employ AI for intelligent contract review. Comments can enhance AI accuracy in identifying risks and issues, enhancing contract legality and completeness. Additionally, legal professions can use AI to generate draft contracts, improving efficiency. And fourth, AI in use in massive service. As public demand for legal services grows and traditional public legal services models revealed in inefficiency and high cost and uneven quality. And the rise of AI technology has introduced AI lawyers and providing inclusive legal services that reduce lawyers' shortages. For instance, in Kulen Bureau of Justice in Tongniao City in the Mongolia Autonomous Region, China, has pioneered integrating the DeepSeek large tools model into a mobile public legal services platform, updating self-service terminals with AI. And last part, I'd like to share something of challenges and strategies for AI legal applications. So as we know, AI algorithm may contain biases and errors affecting the accuracy of legal decision. For example, models trained on historical data may reflect social biases, undermining fairness. To reduce such risks, we should establish strict technical verification and auditing mechanism, and with regular evaluation and updating of AI tools. In legal services, particular caution should be paid to AI hallucinations. That is fabrication by AI, which are inherent to development. And second challenge is data security and privacy protection to legal information. When we use AI tools to produce AI data, strict compliance with data security and privacy law is essential. We should establish a robust data management system and ensure confidentiality. Meanwhile, measures including data notifications, encryption, and civil access controls. And a third one is the technological defense. Over-reliance on AI may erode and reduce legal professionals' skills. So therefore, lawyers must approach AI as a tool while maintaining professional boundaries. So therefore, there are some initiatives, including organizing seminars and training on AI and the law to share the best practices, as well as a foster collaborations among legal institutions, regulations, and academia to promote ethnic AI development in the legal field. Last, I'd like to make a conclusion. AI is not a replacement for the legal professions, but a catalyst for innovation. By upholding the rule of law, embracing innovation, and deepening global collaboration, we can grasp transformation and turning AI into a digital hand of justice and safeguards fairness and equity. Thank you.
Thank you very much, Chen. And may I now request Jung-Woo Kim from the Korean Bar Association, where he's a member of the International Committee, to make his presentation.
Good morning, distinguished colleagues. It's an honor here to represent the Korean Bar Association at the POLA Summit. This theme, Courtroom Without Walls, holds a dear place in my heart because, as many of you know, last year when the South Korean president enacted martial law in South Korea, and it led to his ousting and his impeachment earlier this year, this is exactly what we observed in South Korea. Also, secondly, as I also own and operate, I founded an AI technology startup, actually right here in India, with offices in Noida, Pune, and Bangalore. I think I see both sides of these things happening. And I would also like to say, आपसे मैं कर खुशी हुई. मेरा नाम Felix Jung-Woo Kim है. And thank you so very much for hosting us. Our theme today is Courtroom Without Walls. This phrase is not just about technology or modernization. It is about how law, truth, and legitimacy are being stress tested in a digital-first era. I want to argue that the real challenge is not whether AI or social media will change the courts. They already have. The real battle is whether courts can preserve their legitimacy and trust when justice is lived out on screens, algorithms, and viral feeds. Courtrooms today are no longer confined to marble halls. Like I have mentioned before, in my country, South Korea, has experimented with opening high-profile cases to the public, including constitutional hearings like the impeachment of the president. More than 20 million people live-streamed constitutional hearings in South Korea, and this is historic because never before have citizens had such direct access to judicial reasoning. Transparency, in theory, strengthens legitimacy, but here comes the danger. When justice becomes performance, the risk is that cases are decided not in law, but in the court of public opinion. So the first point is, virtual courts must be designed for due process, not for virality. Otherwise, law becomes no longer the law, but entertainment. Artificial intelligence is also already inside our courtrooms, quietly, almost invisibly. Platforms like Harvey AI and Casetext are drafting briefs. Predictive models can forecast case outcomes with 70 to 80% accuracy, and in South Korea, judges are piloting AI-based sentencing assistants. These tools can save time, reduce costs, and democratize access to legal knowledge. But then again, on the other side, when lawyers and judges begin to defer to the machine, human ethics, as many of us have pointed out today, erode. A model may predict, but it cannot deliberate. It cannot understand fairness or equity. Now let's turn to social media, the second wall that has collapsed. The Oscar Pistorius trial, or the Me Too movement, we observed that hashtags often determine reputations before verdicts. In many cases, reputations were demolished more than they could have ever been recuperated. The reality is that judicial independence is no longer threatened by the algorithmic crowd. It is also threatened by political power. And judges are human beings. When millions of people are posting, trending, and demanding a certain outcome, the psychological weight is immense. So what we must do is we must learn how to shield courts from impartiality, from this pressure. Otherwise, justice risks being crowdsourced, and crowds, as history reminds us, are rarely just. At this point, you may notice a common thread. The rule of law, the central risk is not just AI, nor live streaming, nor hashtags. The central risk is the erosion of legitimacy. The rule of law does not rest only on whether the judgment is correct in substance. It rests on whether citizens believe in its fairness. If people believe that TikTok or X are more fair than the justice system, the entire foundation of law begins to crumble. This is why we argue that the real fight is not law versus technology, but law versus loss of trust. And colleagues, once trust is lost, it is nearly impossible to gain again. So what must we do? As a representative of the South Korean bar, I believe that courts must, we believe that courts must transform from being passive venues of adjudication into active guardians of truth and trust. We must establish AI audit standards to certify which tools are permissible, and secondly, adopt digital evidence authenticity protocols, metadata, watermarks, etc. to guard against deepfakes. Third, judicial officers must be trained not only in constitutional law, but also in AI literacy and media literacy. Finally, as we all know, no country can do this alone. Disinformation is borderless. We must make cross-border judicial cooperation across Korea, India, across Asia, across different countries to lead a regional alliance against legal misinformation. To conclude, technology has taken the courtroom beyond its walls. AI accelerates, social media amplifies, and deepfakes distort. The decisive issue is not technological, it is moral and institutional. Can we preserve trust in the rule of law? If we succeed, courts will emerge stronger than ever, more transparent, more resilient, more trusted than ever before. If we fail, the rule of law itself risks being replaced by the rule of algorithms and crowds. And a very pivotal moment is at stake in our hands. And thank you for listening to our
Thank you very much, Kim. That was very interesting and fabulous. Your pronunciations of Hindi were near perfect. They were certainly better than mine. Okay, I sort of drifted up to New Delhi from Mumbai, where the dominant local language is Marathi. In the Bombay High Court, there's also a bit of Gujarati which is spoken. Hindi is sort of comes in third or fourth, perhaps, after English. But thank you very much for that presentation. I'm going to throw this open. We have 45 minutes to go, and we will welcome both questions from the floor as well as perspectives from individuals and jurisdictions, both which aren't represented on the stage and otherwise. And I'm just, I had messaged a few minutes ago Mr. Amarjit Vedi as to whether we have a bunch of microphones which are sort of moving around, but if not, that's part of the responsibilities of the chair. So let me just know, I'll just head down there. Come, please. Nixon, you're next.
Hi, this is Jose Marley from the Hong Kong Bar Association. So just in light of what President Warner and also Ms. Lisa Sam said about the downside, in a way, of court hearings either being basically shown live to more people or for the advancement of technology, is that has really caused an upsurge in doxing, especially as societies become more divisive, and we can see this whether it's the UK, the US, Hong Kong, or elsewhere. And it's basically created a greater ease in which people who don't like particular rulings then end up attacking judges. And as the last speaker mentioned, this puts pressure on judicial officers. And so one of the experiences we've had in Hong Kong, as you all know, is we faced some pretty difficult times in 2019, as a result of which some judges were doxed. So depending on whether you came to a ruling which Camp A liked or Camp B liked, you got basically doxed by one, sometimes if you're unlucky, both camps, depending on the result. And so on the 13th of November of 2020, actually, Justice Coleman was faced with an injunction. So the applicant was the Secretary for Justice, which in other common law jurisdictions is the Attorney General, basically applying on behalf of the judiciary to prevent doxing. So of course the hearing has to go before a judge. And just to give you the sort of facts you can all recognize in your own jurisdiction, paragraph 19 of the judgment says this. It says, in that section on behavior, that's as in the affidavit which was filed by a judicial officer, but whose identity was anonymized because you didn't want him to be doxed. Typical posts included, quote, pro-China, pro-communist. Others were, quote, support Hong Kong police. Some of the posts suggested that the judge should, quote, die of bad fortune, that the doxing comment should be continued until he or she is, quote, sanctioned, or, quote, someone hits. One post suggested the whole family of the judge should die. Another proposed the use of a firearm. And I could go on, and I'm not going to read it. People's phone numbers were leaked, the families, the children, and so forth. But one important paragraph deals with freedom of expression, because at the same time, I think we all recognize that there's a balance between being able to criticize court judgments, which we all accept, and moving on to the unacceptable, which is to basically threaten judges and judicial officers. So the judge there says, Mr. Justice Coleman says, I accept the injunction sought may have the effect of restricting certain fundamental rights, including the right to freedom of speech or freedom of expression, as guaranteed by Article 27 of the Constitution. However, the court is to perform a balancing and weighing of various relevant rights and freedoms, including the rights of doxed persons and their family members to respect privacy, as well as the need to maintain public order and confidence in the administration of justice. In any event, it is only unlawful doxing which are intended or likely to intimidate, molest, harass, threaten, or pester, which are sought to be restrained. So this is not always a very easy balance between saying, well, I'm just attacking your ruling, and by the way, I put your photo and I mention where you went to school, to what is actually intimidation, which was mentioned by the last speaker. So I think this is something which the legal professions as a whole, I think, need to think about, because we all know the judiciary in most places can't speak for itself. Thank you.
Thank you, host. Dixon?
Thank you very much. I'm Nixon from Peradi, Indonesia. I'm interested to know first about the presentation from Lisa, the relating between human rights and the social media. Is there any national law from Singapore regulates the infringement of AI and social media into the human rights of the citizen of Singapore? Is there any national law of Singapore regulates the infringement of AI and social media into the citizen of Singapore? And if not, how do the lawyers in Singapore defend or claim the rights of human rights in base of human rights to the infringement which is not regulated yet in the national law of Singapore? And that's for Lisa. And for Juliana Warner, in Australia, I'm interesting to know about the case of 70% of the ethical, yeah, the survival of sexual assault, yeah. And how does the court determine the right or correct evidence? Because lots of data at the moment in the media and the proceeding, and then then how does the court determine, and how does the barrister or lawyer in Australia present it for evidence, digital evidence or social media evidence for defense the plaintiff or the clients? Is there any guidelines for doing proceeding evidence to determine which data is the correct one from the plaintiff or from the social media or from the AI? And the third, because it's interesting, as Mr. Syam Divan came to Indonesia last week, and I also interesting to about the AI and the investment of AI, especially into the personal data protection. We all now is monitored by AI our data. So at any times, we all may lose or stolen our data by AI. And I don't know whether we all here understand and worried that our data, is including the data of banking, will be, announced to anywhere in the world, so everybody can know our account banking, how much money we have, how much money, how many houses we have, and everything can be opened by AI and social media. And this is what my concern now is. Is there any convention, international convention to regulate about AI, social media, so we can have like narcotics, you know, we can have a transfer like any suspicious criminal in AI. Because now as far as I know, there is no convention, law of convention in terms of AI and social media. And I'm really worried if we don't have a special convention in the AI and social media, we are now playing victim by, play around by the any company, anyone who understands very well about AI, and they can sell our data and get benefit illegally from us. Thank you.
Thank you very much, Nixon. Before I let's get answers from the floor to Nixon's questions and his perspectives. He's, of course, as you gathered from the last part of his comments, a data protection expert, private data protection expert practicing out of Jakarta. So, Lisa, would you like to go in first? Just
okay.
your response, and then we can go across to Juliana.
Okay, I would just talk about Singapore court proceedings. In Singapore, we had some political cases, and it went into the social media domain, and the court then switched tracks and basically disallowed any recording by anyone in court. The recording is, however, kept by the courts, and no one is allowed to make any video or audio recording. Okay, so that's the first step they did. They also enacted the Family Justice Act, Section 10, to anonymize all family-related proceedings, not just the details, but also the names. So these days, when we want to cite a case, it goes AAB versus AAC or CCBB, and it's quite difficult. So that they also anonymize a lot of the companies and addresses which can identify a particular person. So in recent times, there is, right now we are looking at transcription, because people bring computers in and they just turn on the app, and you can have a transcription of what's going on, where you could in the past take notes. So we are now actually in the midst of a discussion about using apps to transcribe proceedings. Of course, there is an official one from the courts, but that is under discussion, because people can easily use the transcription and take it to the public domain, and the accuracy is another thing that you have to deal with. So that's what the court had done right now. So a more conservative approach. Then, of course, with the usual publishing of judgments and all that. So what does the Law Society do for our lawyers? We conduct quite a bit of training together with a social media PR experts, basically to teach our lawyers to identify when to respond. Because sometimes some comments can be like a troll, and if you respond to it, it can make it worse. So it is not uncommon for people who receive letters of demand, they receive the court proceedings, to publish the court documents online, and then people will pass comments about, oh, you know, you're bullying somebody. So I give an example where someone went to eat somewhere, and he published a comment about this restaurant, oh, it tastes awful. And the restaurant took proceedings in court to injunct the person from commenting, and the lawyers got involved, and it just went downhill thereafter. So I think training lawyers or law firms to know when to respond and how to respond is important, because it can be perceived as trying to stifle freedom of expression. And if the lawyer is dragged into that conversation, it would not look very well for the profession as well as for the law firm. Then everyone says, oh, you should boycott this lawyer. There were even trolls, like there were typographical errors in the letters of demand. And the comment was, oh, you know, you can't even spell properly and therefore you're not a good lawyer, so that's a troll. So I think helping lawyers to identify when to respond online is very important. Sometimes the best way is not to respond. Okay, so that's one of the things that the Law Society has done. I mean, apart from the usual criminal offenses that are out there, there is no specific hard law. There is a rule, I think, which is present in most common law jurisdictions, is that when you get evidence from a current proceedings, you can't use it for collateral purposes. So the courts do enforce that with contempt of court, even if the parties are the ones who abuse it. So these are the soft approaches. But in general, I think because it's difficult to control once your information is in the public domain, the court has taken a very conservative approach, but no hard law has been put in place to limit people's ability to comment. Okay? Let me see what are your other questions. Have I answered all your questions? Yeah, okay, good.
Hello, can you hear me? So first of all, in relation to, I think you asked about recording in courts, I mean, similar questions to Lisa. You can't record court proceedings. You can just take notes, like in the old days. If it's live streamed, the federal court has its own YouTube channel, but which is different, but you can't transmit that or record that and you know, send it off. But again, you can take notes of whatever is said. In relation to protection of judges and families and so forth, any cases involving children, you can't use the children's names. They're all anonymised. In fact, there was a court case a few years ago where a sexual assault survivor had wanted to.
Sorry, Julia, can Julia be heard at the back? Yes, okay, sorry. Okay.
There was a case where a sexual assault survivor had wanted to use her own name in the press because she wanted to disclose what had happened to her. She'd been groomed by a school teacher as a young girl, and it had been immensely damaging. And she brought some proceedings in the Tasmanian Supreme Court to get a dispensation so that her name could be used. She ultimately became Australian of the Year. Her name was Grace Tame, and she became very famous for defending sexual assault survivors. But the general rule is that no names are for, you know, minors are used in proceedings. In relation to how jurors are protected, again, no photography, no names of jurors are ever made available. They're all told that they mustn't look at social media or read the newspapers while they're in hearing, and the judges reinforce that at all stages. But I think that's really the limit of what has occurred to date. Yeah, I think that's really where we're at in Australia at the moment.
Thank you. I wonder whether Roden or would Jung Woo have any comments or any supplementary remarks? What about Chen? Would you like to comment on any of the remarks which have been made or reflections, or should we just move the questions along? Okay, okay. Anyone else? All right, fair enough. Yes, please. Yeah, please. Thank you.
Very short question. What do you think about the use of platforms of AI by the judge or other participants in the court system? Will it affect the quality of parties before the courts? Because as there will be a huge difference of resourcefulness and support between those who have access to a privileged and well-resourced AI system and those who has not. And in the sense of this, if any judge is allowed to use AI, shall it be freely accessible to all parties and also to the public, and be a part of public service infrastructure to maintain equality in uniform manner? Because as, for example, as Ms. Lisa indicated, there are certain like transcribers and other types of like programs, and if court is using it, shall it be accessible to everyone? And if court is using some kind of AI, shall it be accessible to everyone as a public service in order to maintain equality between all the parties? So as I understood, in reality, there are like paid and specific AI platforms who is not available to everyone, so that attorney who has access to it and attorney who doesn't have access to it will be having a huge difference. And will it be like in line with the principles of equality between the all parties, considering the advantage of the technological advancements, right?
So, thank you very much for that question. So it's really about a level playing field. And
yes.
I think there are at least two dimensions which come out here. One is a level playing field as between two sets of lawyers, and the other is the level playing field between the court on the one hand and the sort of the members of the bar. So I wonder whether there are any reflections on this or any responses to this. Yes, please, Juliana. Yes. And perhaps you could even touch on the issue which was raised, which is, you know, the larger issue of access to justice and costs.
Oh, yes. I was at a function a few weeks ago, which was the 30th anniversary of what we call OSTLI. And OSTLI is a database of all legislation and case law in Australia, in all Australian courts, and all legislation. And it's free, and everybody has access to it. They are developing a large language model based only on the OSTLI database, which they propose to make available to everyone. And I think what they are aiming for, in conjunction with the judges, is to create that level playing field for judges and all participants in the justice system. It's quite a novel approach, and it's completely free.
Thank you. Thank you. Yes, Rodden?
Well, I think, Shyam, I agree with you. It's just a matter of level playing field. Look at that. As I mentioned in my speech, frankly, you know, at the end of the day, it's not about yes or no. It's about when. So at the end of the day, I think it doesn't viable if we do not allow any of the legal profession to adopt AI. Think about it, just using Lexis, for example. They always come to us and doing a presentation that day, okay, our AI model is within our own system. So literally, it ensures that the genuine of all the cases, there's no fake cases, anything. That's something that they always advocate for. I think the UK is already, they implement it. For Hong Kong, I believe that is about next year. That's what they mentioned to us. Yeah. Yeah, of course it's by charge. There's no free lunch. Yeah. But then, you know, I think responding to this question is, okay, we still can, using human discretion nowadays, to control for the judiciary, for the legal profession, how to adopt AI. But my question is already saying that how many years we can still do it, we do not know. That's something that I think none of us can say. Because, you know, think about AI, we're only talking about in these 2 years, it's dramatically changed. For example, in Hong Kong now, Court of Final Appeal already start to adopt some sort of trial online, so people can actually view it. Mainland China, they have trials on the internet that you can view it lively. So we are gradually changing. I'm not quite sure about in India, but what I'm trying to say is, at the end of the day, we will have to face it. Yeah.
Yes, thank you. Any comment on here?
I agree that it's a question of when, not if, because when we look at what's happening in South Korea, for instance, I believe that South Korea the Bar Association, of course, has gone through long legal battles with AI platforms trying to regulate it. I think it's a question of how we regulate it, because I think that a lot of people are using it, and the public especially is already using ChatGPT before consulting an attorney. So I think it's a question of how do we regulate it and how do we fairly make a level playing field. Thank you.
Can I make a comment, Sean? Yes, please. Yeah, I mean, I like the discussion and I think it's correct, but if we are really honest, I think we mix up a little bit. AI, for us, artificial intelligence, we believe will be probably the one who is for us deciding. At this stage, AI, ChatGPT, DeepSeek, whatever, is basically a language-based search engine. If you look at ChatGPT, it helps you to quickly scan the internet, and it comes and then gives you an answer which is much more easy to read. The access to legal information was always a bit inequality. A big law firm always had much more research capacities than a small law firm. So from that perspective, I think we have to watch a little bit that we are not confusing the real challenge with what we have now. Now we have tools which make life a bit more easy. Also before, when I did my doctorate, I went to the library. I didn't probably catch all opinions, and maybe I got some opinions out of context, so therefore they were a bit biased. The main issue, I think, is do we move into an age where the computer is making the decisions? The algorithm is fed with facts, and then this algorithm makes the decision, therefore replacing be it the lawyers or the judges. And in that case, we have this bias and the question mark, how do we regulate AI not to overcome this human judgment? Last comment, we basically praise the human mind and the judges, and basically they're biased as something more acceptable, more trustful. There are researchers where also some people say, well, this is more for a discussion, maybe the next time on the 36th POLA Summit, maybe the judgments we have partially now are much more biased than if a computer would do it. So I think that's where really the battle will lay in the future, to have different research tools shouldn't scare us.
Thank you very much. Yeah, I'll just turn the microphone over. And before that, if I may just make 2 or 3 quick comments. The first is that I suddenly confronted this issue of level playing field when I was writing a message for the moot court, the Law Asia moot court, which is going to be held on the side of the Law Asia annual conference in Hanoi this October. And it struck me as to whether Law Asia has any moot court rules regarding the use of AI. Because I was it was fairly obvious that there were going to be certain teams who were going to prepare their memorials and research on the strength of AI tools, and there were going to be likely others who didn't have that advantage. So it's, it strikes at the very heart, but at a very basic level, even when you're in law school, as to this disparity. And I think what we looked around, and there are certain international moots which have introduced certain norms for mooting and use of AI, and we probably will have to put some rules in place for the 2026 moot competition, though we don't have it here. A couple of perspectives on where AI can play a big role, because I picked this up from our expert panel. One was initiatives by the government. The other is initiatives potentially by the Bar Association, and just to ensure that people have access to AI. So let's just introduce 2 or 3 thoughts here. One is, in a country like India, AI has a tremendous role in terms of access to justice because of the languages we speak. We have over 22 official languages. If you see one of the Indian currency notes, if you happened upon them, you will find the notations in different scripts. And there's many, many more languages. There's over 500 languages which are spoken here. So AI, in terms of just translation, is an enormously helpful tool in terms of accuracy and enhancing, the statements made by witnesses and ensuring that that comes in an accurate form before a judge who may or may not speak the language. So that's very, very big. The second area where, and I pick up on the thought that it's being used which Juliana mentioned, in the family court jurisdiction. When you look at the graph or the pie chart of pending Indian cases which are holding up courts from doing other business, we have two sets of cases which are huge. One is motor accident tribunal claims, and that, the feeling is something which can be, that entire tower can be demolished using AI, because it's pretty standard form. And the other is a whole huge number of cases which are actually on the criminal law docket, and they're because checks bounced. So I realize that in many parts of the world now, checks is an ancient technology, but in India it's still in use. We've of course got a huge digital payment network now in India, which is catching, but this is another pendency area where it's a very simple case, and we may just have to have an AI judge or a tool which can really progress those types of matters. But those were just a few comments from the home jurisdiction here in India. May I just pass it on for some more questions?
A very good afternoon to everybody. I'm Dr. Pooja Agarwal, and I'm representing the Bar Association of India. I would just like to give certain comments with regard to live streaming. We have been discussing about AI, but when we talk about live streaming in India, from my personal experience, I have some bad experiences. For example, during live streaming, the entire proceedings are being live streamed, but there are certain YouTube channels, they just take an excerpt from a particular proceeding and they publish it by putting a headline, or we can say a punchline on it, and it comes out as a very viral video. The second thing is, we are professionals. We know what to do, when to do. There are certain times when we don't speak in the court due to a certain reason, that maybe we don't want to open our trump card or whatever it is. But with live streaming going on, the clients now think that, oh, my lawyer is not performing well in the court. They are not speaking. But they don't know the reason why we are not speaking at a particular point of time. They are not professionals in this field, and that is why they engage us. So these are certain disadvantages which I feel that it needs to be looked into. Thank you.
Thank you very much, Pooja, for those perspectives. Is there anyone else in the audience who would like to raise an issue or share a question? Anything? Anyone? Well, I would just like to do a quick straw poll and request everyone in this room, most of us are practitioners, how many of us on a daily basis use AI in the course of our work? Okay, so should we start? All right. Well, there's the experts on the panel. Yeah, if you could just sort of raise your hands. All right, fair enough. A few, but it's not sort of completely pervasive across the Asia Pacific, as I can tell, at least from here. And the second question is, how many use social media for the purposes of, projecting cases either through their bar associations or through their client base? Is there anyone over here at all? Okay, is it essentially through the bar association, or is it also the firm?
Yeah, Law Council has
Law Council, of course, has
media
has a wide reach. Okay. Thank you very much for those. So I will just well, I don't need to be up there because I have a microphone. I just have a few other questions, essentially directed at the panelists, and I'm going to request them to respond as they please. But may I just inquire from Juliana? There is this, we're talking about social media, and it was essentially in the context of courts, how it can, influence public opinion and the problems that faces. But Australia has a remarkable initiative in terms of legislation as far as access to social media and children are concerned. So if you could just tell the audience about those developments, and if I may immediately thereafter come across to the Korean example, because we just learned that Korea has banned cell phones across all schools. So what prompted that, and what do you think the fallout will be on Gen Z and the youngsters who go to court? Yeah, please.
There's a lot of concern in Australia about the effect that social media is having on our youngsters, particularly the 10 to 15 year age group. There's a lot of concern about mental health issues developing in ways that we've never seen before. There's online bullying, there's inappropriate sexual stuff on social media. And our new Attorney General, funnily enough, has young teenage children. And she was previously the communications minister, and she's an expert in telecommunications and digital law. And she has brought in legislation that bans social media for children under 16. Now, everybody knows that kids will get around that, but it's seen as better than nothing. Having said that, the Law Council sort of wryly makes the point that it's good for this government our current government, to be recognising the damage done to children by public shaming and social media under 16, but we still are incarcerating children under 14, and that's unacceptable. So we make that point regularly, but we do applaud the social media legislation.
Is it without precedent globally? Is it a first?
I think it's a first.
It's
yes.
a first. Okay.
Yes. The social media tech bros in the US are not happy about it. The government has also sort of taken on the tech giants, because they're trying to make the tech giants pay for news content that they lift to put on their platforms. So there's a bit of tension there.
Okay.
Yeah. So for South Korea, I think it's a very interesting point of contest, because South Korea has recently banned cell phones in schools. And a lot of that is, I think, similar to what we discussed today, because a lot of the rationale behind that movement was because parents were live streaming, secretly live streaming how teachers were educating students, and they would lodge complaints and litigate against teachers, especially in discrimination cases, and that led to, that was a huge impediment to bar any mobile phones from being accepted into schools. That being said, recently, still, even after that ban, parents are still live streaming teachers' education methods, and we're currently disputing in court whether that would be fall into illegally contacted evidence. So that's something. Yes. But yeah, that's something that's currently underway and is currently in the appeals court. So we are looking at that very closely to look at the results.
Thank you very much. Of course, the Korean Bar Association, I have to say, played an absolutely stellar role when it came to what was mentioned a short while ago in terms of the martial law being directed and Parliament being convened. And within hours, I was speaking to distinguished representatives from the Korean Bar who serve on the executive committee of Law Asia. And initially, there was complete disbelief. So, you know, the way it worked was that many people thought it was fake news because it was just felt that it was just impossible that something such as this would happen. But then when there was a realization that, that there is truth behind this move, there was a very swift mobilization. Social media was absolutely the key because that was the manner in which the message got across. And the KBA was swift in making statements and providing guidance to the members of the public, which I'm sure at a certain level, you know, was a form of public education, which was absolutely essential at that point. So that's very, very significant. I was wondering whether, Chen, you would have some additional perspectives on innovations which are being used in China. In terms of, you know, as you did mention that, look, we don't want algorithmic justice, the rule of law, ethics, these are some of the challenges. But are there any sections, because China is so far ahead of the rest of the world in this particular area, do you have any successful dispute resolution models which are entirely AI generated? I know that in certain types of consumer disputes, low-level cases, parties can actually agree to AI-enabled arbitration. Is that catching on, or does that happen, or is it still very experimental?
Okay. So first, I'd like to share some just the legal framework on the China. There are data protection law and internet security law, and also personal private protection law in China. Just as your question you mentioned, I think there are also some cases to illustrate such kind of work. But you know, actually AI is widely used in China, also in courts. As far as I know, there are widening application in international arbitration, but we are still believe the AIs cannot replace judges or arbitrators. But frankly speaking, it can first greatly facilitate their adjudication and also especially international arbitration. And just take Kunming Arbitration Committee in my city, for example. We use a lot of AI or DeepSeek in the arbitration. Okay, also some in the people's courts. I think.
Thank you very much. Thank you.
Thank you.
Any further comments or questions from the floor? I'm happy to, if in the meanwhile there's been anyone who has some further ideas or sharings, then this is a good time to, yes, please.
Hi, my name is Jaya from Malaysian Bar Council. I think it's understandable that there's a lot of concern in the legal profession insofar as the impact of AI is concerned and how it will affect the way the judiciary operates as well. But I think we must also should not overlook the fact that AI has actually helped to level the playing field within the legal profession itself. Because firms that are big, the established firms, they have all the resources financially to deal with. Whereas smaller firms, at most of the time, they were not able to compete because of the limited financial resources, logistics, and location. But AI has helped to increase the game for the small firms, especially those operating remotely with limited financial resources. So therefore, I think the bar, apart from educating the public and the profession about the potential risk of AI, should also look into exploiting AI in order to level the playing field within the profession itself. Because that ultimately helps access to justice, it improves access to justice. Why? Because it adds weight to the principle of equality at arms. When both parties goes to court, there should be some level of equal playing field, equal at arms, in order for the access of justice to be meaningful. So therefore, I think the bars, while educating the public, forewarning our members about the risk of AI, should also look to use AI to increase the abilities of our firm, especially those mid-range and smaller firms, and those operating from remote locations. Just a comment. Thank you.
Thank you very much. Thank you. Any other comments or observations? Any other questions from the floor? Yeah, so I'll just, a couple of sharings. One is with regard to virtual courts, which came about, courtrooms without walls. And in India, again, what happened was that there was an enormous explosion of networks during the pandemic. Soon after the pandemic went into retreat, you had a situation where several of the courts, which were fully rigged up with the apparatus, were sort of started dismantling and mothballing all of this equipment and saying we're going back to the same old school method, which required an administrative intervention by the Chief Justice of India, and Justice D.Y. Chandrachud sort of sent word across to all the tribunals and the courts across this vast country saying that no, we've set this up at great expense and cost, and it must be available to citizens who want to access this. Now, who want to use the virtual courtrooms. So there's still a considerable amount of resistance amongst certain judges who are much more comfortable in the old sort of physical courtroom space. But there is, across India now, an option which is available. This is enormously efficient for a number of, well, essentially for the litigant, because the litigant in a tiered and a vast system like India, where you probably have to engage lawyers in different cities, if you want, the court I practice is the Supreme Court of India. But each of these cases is started at a lower level, district level. And it could often happen that the district lawyer is just more familiar with the case and more passionate about it, and is probably in the client's interest more likely to be able to persuade a bench. Now, this wasn't available earlier, but with virtual courts, the client has an option of sticking with his lawyer and not necessarily going to a lawyer in another city where the appeal is being heard. So I think that's certainly an improvement. A second element here in India was, it has to do with the bar, essentially. And it had a huge gender advantage. So what we found was that because of, you know, our society being structured as it is, which is in terms of gender biases and social responsibilities, which you know, go with a largely patriarchal system, young women lawyers found the virtual system a tremendous advantage. And they found it an advantage at many levels. First, they could do it from the comfort of an office space or a residence and access the court and present their cases, which otherwise they would have had to probably abandon a set of their responsibilities. And so they felt invested in this system, and they felt that this was a very favorable manner of doing work. They could strike a much better work-life balance that way. Secondly, and I'm not sure how many of you have visited an Indian court, but even our appellate courts are very, very crowded. So women just found that much more comfortable working out of an office desk and making a presentation than all the jostling which was associated with a typical Indian courtroom and, you know, the physical brushing. So there are these new technologies certainly bring about huge advantages. Just one final point in terms of access to justice and the level playing field issue. The point arose for the first time, I reckon, sometime in the 1990s, long before AI. But we had this huge inequality when the first computerized databases for research came along. And the large firms, as we mentioned, and the well-heeled lawyers were able to afford these databases. And suddenly you didn't have to go into the physical library and pull out books, which became a big, big advantage for those who could pay these subscriptions. The way that model worked out was that several bar associations and bar libraries negotiated with the computerized databases and allowed a subscription model by which lawyers didn't have to pick up the entire package, but could subscribe through the library for an hour or two. So that's perhaps, in terms of these powerful AI tools which are coming about, both courts can make it mandatory, or courts can develop their own AI tools, or bar associations can enter into some sets of negotiations with the AI providers to ensure at least the large language models which are generic in nature, not the ones which are tailored to a particular firm, those become available at a reasonable cost. So I thank you all for attending this session. It's been a real pleasure, and may I request each one of you to sort of acknowledge this brilliant panel in the traditional manner. Thank you. Come, make the announcement. Yeah. Sorry, the President's, I might just I have an announcement to make before the photograph.
Meeting is rescheduled at 1:45 instead of 2.
Oh, okay. The President's meeting has been rescheduled. The President's Summit meeting number 1, same venue, Magnolia Hall, will now be 15 minutes earlier at 1:45 p.m. and not at 2 p.m. So that's just an announcement from the floor. May I request all of us to just have a photograph? Yes. Come. Thanks very much. Thank you. Thank you.
think we have a quick 1 hour to have the first round of the President's Summit meeting of this 35th POLA Summit. And I hope that despite being immediately after lunch, we are all attentive and not half sleepy. The agenda is stimulating enough to keep us engaged. It is the outpouring of love and affection that the table has space for us and all the magnificent gifts which have piled on the table as well, apart from the attendees, including some very beautiful teddies. But this is what is the pleasure of being in a gathering like this, where we remember each other, we bring gifts, and we try to become friends and family. So we tried to adjust a visit to Supreme Court and a special meeting hosted by the Chief Justice of India, along with his two senior most colleagues, for the leaders of POLA organizations. So that's why we thought that we'll have the President's meeting and then immediately leave for Supreme Court. We are, entry of vehicles and all has a security protocol. So, but everything is arranged. But we'll try to have the proceedings in a way that what part of the agenda we cannot complete today, we carry on for tomorrow. Okay? So I'll make my welcome very brief because I welcome each one of you in morning as well. But in this summit meeting, I only want to add that unless until there is an express agreement, the proceedings of this meeting remain confidential and minutes are circulated to the presidents. But we can take a conscious call on any issue where we can circulate the information or endeavor which are of general nature. This is important because some of us may have certain developments to share as colleagues, as confidants of each other, which should not travel beyond the four walls here. So that is to ensure that the deliberations can be most open and frank. With this, I want to commence the formal agenda. That is confirmation of minutes of the President's meeting held in Hong Kong on 8th June during the 34th POLA Summit. You have the minutes circulated earlier, and we have placed a copy in the papers here as well. And while circulating these minutes, we must thank the two Hong Kong organizations, Law Society and the Bar Association, for hosting 34th POLA Summit in a very grand and magnificent manner. I could not attend, but my colleagues were very full of praise of excellent arrangements made by Hong Kong. So if you have had a look at the minutes, unless there is a comment or some observation, we can proceed to the next agenda. So we take the minutes as confirmed. I need a proposer and seconder. Yes. No issue, that we take due cognizance of. Support. So we take the minutes as confirmed. Thank you. And once again, we place on record in the minutes of this meeting our gratitude to Hong Kong organizations. Thank you. Now, one of the major initiatives which was formalized was during 33rd POLA meeting in Malaysia. And Malaysian Bar has come forward to create a facilitation center for POLA because the organization does not have a fixed secretariat. Each year's host maintains the records of that year. So we thought that a continuity is required, and Malaysian Bar very graciously presented itself. So if I can request a very brief 4-5 minute meeting that what has been achieved and what are the further cooperation required from members.
Thank you very much, Chair. So for the report for the facilitation center, so in order to compile previous records, the annual report is inside the bundle. In order to compile previous records, we have sent out email requests to POLA members on 3rd October 2023, 22nd November 2023, and 25th February 2025. The latest email is in Appendix 1. So the report, the document in front of you will report on the following areas: directory and contact details of POLA members, list of previous POLA conferences, minutes of previous President Summits, and archive materials. So for one, the directory, for now, just to inform members, Ho Chi Minh City Bar Association is no longer in the directory. And number two, we can't find any details regarding Burma Lawyers Council. So the proposal that we have is 3 proposals. One is that we seek the assistance of members of POLA to provide us with any contact information that they have about Burma Lawyers Council. Our second proposal is that a committee is being to establish a committee to look back at our Article 4 membership. So it's too long. We have 6 paragraphs there. And maybe to examine and to make it shorter and more comprehensive. And number 3 is that we seek the assistance of members of POLA to see their records for any minutes that is not listed in the archive. That's all, Chair.
Thank you, President, and with everyone's permission, we will make these proposals as part of records of the minutes of this meeting, and it will be circulated so that these proposals can be acted upon. So thank you, Malaysian Bar, and thank you, President, for this report. Then, friends, we had circulated a note from the JFBA, Japan Federation of Bar Associations. The email with that note is also part of the documents provided to you, and it was circulated as well to all the members, and we did receive some responses, including from Singapore. So I will request JFBA to make a short presentation on how they want POLA to contribute to this.
Hello, everyone. I'm Reiko Fujigami, the President of the Japan Federation of Bar Associations. I would like to propose the revision of trial laws and criminal justice reform as the topic for today's discussion. I will now speak in Japanese. 日弁連は1959年以来、再審支援に取り組み、これまでに36件の再審事件を支援し、そのうち20件について再審無罪判決が確定していますが、その活動の中で日本の再審制度、刑事司法制度の問題点が明らかになっています。
Japan Federation of Bar Associations, JFBA, has been supporting retrials since 1959 and has provided assistance in 36 retrial cases to date, with 20 resulting in final acquittals. Through this work, issues with Japan's retrial systems and criminal justice system have become evident.
日本の刑事訴訟法の中で再審の規定はわずか19条にとどまり、現行法が施行されてから一度も改正されておりません。
Under Japan's Criminal Procedure Code, provisions on retrials are limited to just 19 articles, and the current law has never been amended since its implementation.
再審請求審における具体的審理の在り方は、裁判所の裁量に委ねられており、証拠開示の基準や手続きは明確ではなく、また再審開始決定がなされても、検察官が不服申し立てを行う事例が相次いでおり、冤罪被害者の速やかな救済が妨げられています。
The specific procedure for retrial hearings are left to the discretion of the courts, with unclear standards and procedures for evidence disclosure. Additionally, even when decisions to grant a retrial is made, cases where prosecutors file appeals are increasing, hindering the prompt redress of wrongfully convicted individuals.
静岡市で1966年に発生した味噌工場一家4人の殺人事件で同年逮捕された袴田氏に対する再審無罪判決が2024年9月に出され確定しました。
In 1966, a miso factory murder cases in Shizuoka City, where 4 members of the family were all killed. The retrial acquittal of Mr. Hakamada, who was arrested in the same year, was finalized in September 2024.
袴田氏逮捕から58年、2014年3月の再審開始決定から10年半も時間を要しました。
It took 58 years since Mr. Hakamada's arrest and 10 years and a half years from the decision to grant a retrial in March 2014.
続いて1986年に発生した福井女子中学生殺人事件では2025年7月に再審無罪判決が出され確定しました。
In another case, the 1986 murder of a female middle school student in Fukuoka Prefecture resulted in a retrial acquittal in July 2025 this year.
無罪まで38年も要しました。他の事件でも同様の問題が生じています。
So it took 38 years for the acquittal to be finalized. Similar issues are arising in other cases as well.
日弁連は再審請求手続きにおける全面的な証拠開示の制度化の実現、再審開始決定に対する検察官による不服申し立ての禁止を含む再審法の速やかな改正に向けた取り組みを進めています。
The Japan Federation of Bar Association is advancing efforts to achieve the institutionalization of comprehensive disclosure of evidence in retrial proceedings including the prohibition of prosecutors' appeals against the decisions to grant retrials and expedite amendments to the Retrial Act.
再審請求手続きの規定を整理する刑事訴訟法改正案、再審法改正案が国会議員によって本年6月の通常国会に提出されましたが、継続審議となっています。
A bill to amend the Criminal Procedure Act, Retrial Act Amendment Bill, to establish provisions for retrial procedures was submitted to the regular sessions of our Diet in June this year by members of the Diet. However, it remains under continued review and never been put to a vote.
再審法の問題に加えて、冤罪の発生には無罪を主張し、または黙秘権を行使している被告人が保釈されず、自白しない限り長期間にわたり身体拘束され続けるという人質司法の問題があります。
In addition to issues with the Retrial Act, there is a problem of hostage justice, where suspects who claim innocence or exercise their right to remain silent are not granted bail and remain in custody for extended periods of time unless they confess. The JPA is advocating for reforms to the criminal justice system.
日弁連は刑事司法改革の課題として取り調べにおける全事件全過程の録音録画の義務化や取り調べにおける弁護人の立ち会い権の保障などを訴えているところです。
One of the endeavors that Japan Federation of Association is advocating is to promote the mandatory recording of all interrogations and the guarantee of the defense counsel's right to be present during the interrogation at police.
今後の当連合会の再審法改正及び刑事司法改革に向けた活動の参考とするため、各国の再審制度や刑事司法制度の状況についてお伺いしたいと考えております。Thank you for your kind attention.
In order to serve as a reference for our future activities regarding the revision of the Retrial Act and criminal justice reform, we would like to inquire about the status of the retrial systems or any of the law revisions related to the retrial law in your own countries and jurisdictions, and also the issues related to the criminal justice system in your countries. Thank you.
Thank you. Thank you, President. I think the issue of a right to retrial is a very important right, because whatever degree of perfection we expect from a judicial system, which also depends on evidence gathering and other aspects, and there are various dimensions to it. One, ultimately in every legal system, it is not just an issue of crime and punishment, it is also an issue of finding the truth. And sometimes finding the real truth is very difficult, and one goes on a very high bar of probability, ruling out any other thing, but that does not 100% rule out any scope of mistakes. And sometimes also an evidence can emerge due to new technology, like you can have some evidence reanalyzed using new tools including DNA, and you find something which had happened, and the conclusion of trial is sufficiently disproved by this new discovery or new fact. That's why it is important that the systems have a scope not only to deliver justice, but a capacity to correct mistakes, to prevent injustice which might have taken place while doing justice. So it is a very important aspect which Japan Federation has highlighted. We have received some responses, but not from all. And I think if we can receive more responses that how this issue is dealt with, I think it will not only be a contribution from POLA to assist JFBA in guiding the process by having cross-section of practices and norms in various jurisdictions within POLA, but also each one of us, because we may or may not be having these provisions, but whether they can be further strengthened, whether we can learn from each other. So having this repository of knowledge in this particular subject will be important. So you can send it to Bar Association of India. We will forward it to POLA Facilitation Center, and we can work that, some kind of analysis or a short note is available as part of attachment to the minutes of this summit when we circulate it. So if we can set a timeline that in 6 weeks from now, because each one is very busy and it is not easy to collect this kind of information in very short period. So if you agree to 6 weeks, I propose 6 weeks, but if somebody has a different view, I welcome it. Otherwise, we set 6 weeks for further responses to come on this. Now friends, I wanted that these formal agenda items on report and retrial law are done with. Each one of us has been meeting from yesterday, at least some of us, over dinner graciously hosted by Shyam, and today during the sessions. But still, I think it will be very nice if we have a round before we have the country report presentation, where each one of us introduces oneself. So we are the hosts, will come last. So we invite Madam President from Law Council of Australia to introduce, then we go around the table. Yeah,
Hi everyone, I'm Juliana Warner and I'm President of Law Council of Australia, and I'm really enjoying myself here. It's been great. And thank you for dinner. It's fun.
We are going alphabet-wise in this seating arrangement, but we changed a little because the space was restricted. So I'm very thankful for ACLA. But in the manner of speaking, they will come in the alphabet form. And for Bhutan, Bhutan is not a member yet, and they have a bar council which has been formed not so long ago. And that's why we thought that we invite them to POLA so that they understand the values, ethos, and the whole culture of this organization. So they taste it, apart from Indian food, which being in Bhutan, they are almost accustomed to. So please welcome Bhutan, and
we have to see to it that they are motivated enough to formally apply to join POLA.
So with this, my name is Ranjan Penjo, and I'm from Bhutan. I think Bhutan is squeezed in between two very big countries, China in the north and India in the south. But nevertheless, we are very close and most trusted friend of India in Southeast Asia. So currently, I'm the Vice President of the Bar Council of Bhutan. As I think the President of the Bar Association of India said that the Bar Council of Bhutan was in fact introduced in 2002 when I was a judge in the Supreme Court of Bhutan. So I was also responsible for founding this very particular bar association, but at that point of time we had not so many lawyers. There were only about 20 to 30 lawyers. So we could not actively, I think, carry our duties. As of now, we have about 425 registered lawyers with us, and many of these lawyers have studied from the various universities from India, Nalsar, the National Law School, Bangalore. And in fact, as I'm very highly motivated, and I want to again thank the Bar Association of India for inviting me, graciously inviting me to attend this particular, I think, summit. And the Bar Council of Bhutan, including myself, I think we are seriously considering about becoming the member of the POLA, and hopefully we will be able to do it within 1 month from now. Thank you so much.
Hello everyone, my name is Zainidi. I'm from Brunei, President of the Law Society of Brunei Darussalam. Yeah, I'm also a little bit not sure about our status here. I am here being invited thanks to my colleague from Law Society of Singapore asking Mr. Prashant to extend the invitation as an observer. But I'm here with the main table and then listed as a member in the list of attendees. So yeah, we'll sort that out later. But we are Law Society. I think I didn't realize we have so much in common with our friend from Bar Council of Bhutan. We are about 20 years old. We are actually a statutory body, just much like the Singapore Law Society, which we use as a template in terms of our organization. In our young 20 years, we have only now have just a bit less than 200 members. All the practicing lawyers will have to be a member. A lot of us, the older generation, certainly trained in England, and also we are barristers in England, most of us, and also our qualifications also can be had from Malaysian the examination that they provide. Apart from that, we hope to be able to. We are extending our reach now. We are very active in the ASEAN region. We've just attended, I know many of the ASEAN bar leaders here, and I'm happy to be able to see more people from the bigger Asia. So thank you very much. We'll talk later on the status of our membership, on how to apply. Yeah, thank you.
Since we have been having Brunei in law.